normal procedure is once an investigation is over, the investigating agency, which was SIT in this case, files what is known as a final report before the magistrate. Final report is either a charge sheet or a closure report. A charge sheet is if you find that if the investigating agency finds that a trial should be conducted, then you file a charge sheet, name persons against whom trial should be conducted, and point out why trial should be conducted. If on the other hand the investigating agency finds that there is nothing, there is no reason to carry on with the trial, the investigating agency would file what is known as a closure report. Now in this case, the investigating agency, what they had done, SIT, it curled out from the complaint of Zakia Jafri about 32 points and said that in none of the points is there a triable case made out. This is what she said. The law is that if the investigating agency files such a report, then the person who has filed a complaint has a right to rebut that report by filing what is known as a protest petition and saying that asking the magistrate to reject the the closure report and take cognizance of the offence. So in this case also, Zakia Jafri finally, after she managed to get access to all the documents which the Supreme Court directed, she files a protest petition. Protest petition is three prayers. I'm sorry. One is that on the basis of the existing evidence, there is enough material to charge the persons whom she had named as accused. That was one. Second, alternative prayer was that if not, at least allow further investigation because the investigation has not been carried out properly. Okay? This is a right which the complainant has to agitate before the magistrate. So she agitates that allow them to carry out further investigation. And the third is that treat the protest petition itself as a complaint. Okay? Because we have been able to point out in the protest petition various facts which the investigating agency has ignored or has sidetracked. So all these three prayers were made before the magistrate. Magistrate refuses all the three prayers and accepts the closure report. And he refuses the further investigation not on the basis that there is no case made out for further investigation, but on the basis that I have no power to order further investigation. Now against that we come to the High Court in the revision. Now you must remember that revision powers are very limited powers under the Criminal Procedure Code. Because the law is that if there are two views possible and on the basis of the evidence and one of the views is accepted by the magistrate, that even if the High Court disagrees with that view but treats it as a possible view, High Court will not interfere. Okay. So here what High Court does in the revision is she says that it is she doesn't discard Zakia's interpretation of the events. Okay. But what she says is that even if there are two views possible, since the magistrate has given the reasoning and come to one view, I have no judicial power to interfere interfere in that view. Okay. So in that sense, she says I will not interfere in the revisionary jurisdiction. She, however, comes to the conclusion that the magistrate's finding that he does not have power to order further investigation is wrong. She says that the High Court says that the magistrate does have the power to order further investigation. Whether it should be ordered in the given case, in this case or not, is something which the magistrate will have to decide, or the High Court in the companion Gulberg matter will have to decide, or the Supreme Court will have to decide. But the magistrate is wrong in saying that I don't have the power to order further investigation. So that therefore she says that I am partially allowing the revision application. Okay, by holding that this finding of the magistrate is wrong. But I would rather than take upon myself the burden of deciding whether further investigation should be ordered or not, she says that it should go back to the magistrate or to the in the companion matter in the High Court. This is what she says. Yes, absolutely, it does, because she had agitated that earlier, which was ignored by the magistrate. What the High Court says, no, you have a right to agitate this, and you can agitate this if you want to. So it gives a possibility of going, as I said, either to the magistrate or to the companion matter in the High Court, and saying that that SIT's investigation was not adequate for reasons A, B, C, D. For instance, just to give you an example, Zakia had argued that don't just look at what happens after 27th, when the Godhra violence takes place. Look at how there was a build-up to these riots. It is nobody's case that Godhra was planned by Mr. Modi or something. That was not the case. The case was that the government or the party in power was looking for an opportunity to start some kind of a carnage, or to allow a carnage to be started. That opportunity was given by what happened with Godhra. But the party in power, as well as various other right-wing organizations, etc., were already making adequate preparations much before Godhra, even before 27th February. The whole question of prelude, as to what happens, how the build-up to Godhra was happening, how various venomous ideas were being spread, how arms were being collected. So all these things she had brought in. Unfortunately, SIT, and when you are talking about conspiracy, you are not talking about conspiracy which starts at one point of time. You are talking about a larger conspiracy, command responsibility, a larger conspiracy which has its roots way back from 27th February 2002. For that, the SIT ought to have looked at what documents, and there were documents. It was not as if we were talking out through the head. There were intelligence bureau reports, recordings, messages, etc., etc. From Gujarat, from UP, etc., which were brought on record, which were on record of the courts, and which were before the which were with the SIT. But SIT completely ignores. So when I said that SIT culls out 32 points from what Zakia had complained, those 32 points miss out completely the prelude. So one of the arguments which was raised was that as far as the investigating agency is concerned, they have not gone into the prelude at all. Neither the magistrate goes into it, nor the High Court goes into it. But this is an aspect which needs to be further investigated, because it was not investigated at all. Similarly, just give you another example. The SIT did interview Modi, but it was like Arnab Goswami interviewing Modi. It was a friendly chat, question answer. It was not an interrogation. Now he was the main accused according to Zakia. He should have been grilled in the interview. Instead, what happens is a kind of a friendly chat in a question answer form. I don't know whether he was given the questions in advance or not given in advance, but whatever it is, there is a question answer form, friendly chit chat happening. But if you look at what he said, look at how he answers. It's obvious that there was no hard questions put to him. He was given questions to which everybody knew what he's going to answer. So the way the whole investigation was conducted in respect of Mr. Modi's role also, were left much to be desired, and that's why we were saying that have a further investigation. Asking hard questions. Don't ask him soft questions like where were you on 27th February and did you do anything to stop the riots, and he'll say yes, I went on TV one day and told everybody to keep calm, kind of thing. That's not the issue. And everybody does that. Hitler did that, keep calm, keep calm. That doesn't really help us. See, the way, if I read, my reading of the SIT report is that they had first arrived at the conclusion and then carried out the investigation. Okay, this is how I would look at the SIT investigation. Okay. They had first I mean, just look at the infamous meeting of 27th February 2002, okay, where Mr. Modi is supposed to have made certain statements. Okay. Those persons who supported Modi, okay, were asked 2, 3, 4 times. Those who did not, okay, were asked once and then ignored. Okay. Those who did not, meaning those who were present in the meeting and did not support what Mr. Modi had said, okay, about that meeting, okay, were asked once and then ignored. So the way the investigation was carried out, okay, I felt that there was much left to be desired. Similarly, there were telephone records, okay, of 27-2 onwards, okay, of Ahmedabad city, which would show where each person was at different times. Now, those telephone records, though they were brought to their knowledge, the SIT did nothing to analyze those, and it was in fact we who had to analyze those and give it to the court, that this is the actual analysis of the record, which showed various things which could have actually, if there was an independent investigation, then it would have brought to light many more things than what the SIT claimed to have happened.